Thank you, Eric. Our next speaker is David Dana, who's Associate Dean for Academic Affairs here, as well as a Professor of Law, specializes in the area of environmental law.
Thank you. Well, every year in the spring I teach property, and when we get to the section on nuisance, we talk first about private nuisance law, and I ask the students what a private nuisance is, and they recite what their outlines say that they got from the last year class, which says an unreasonable interference with the land use or the use of land of another. And it's very hard to know what that means. But then when you move on and ask them what public nuisance means, you get complete silence, because even their outlines don't really say. Because there really isn't a good operational definition of public nuisance. Private nuisance can be very broad in the common law, and we think of it but we do at least usually relate it to damages to land, and we usually relate it to some kind of invasion onto land, of kind of fumes or something else. But public nuisance historically is all over the place. Public nuisance can be a drug den, public nuisance could be a dilapidated building, it could be a house of prostitution, it could be pollution, it could be all sorts of things. And so it's very hard to actually cabin the definition. And one of the concerns about the use of public nuisance litigation, even to address problems that perhaps should be addressed elsewhere, is if it has no limitations what public nuisance is it creating a sort of an open box that might lead to too much litigation, too much calls for judicial intervention. And that's one of the essential problems, I think, with public nuisance litigation generally, is you're starting with a category that almost doesn't have definition. Another kind of concern that relates to Professor Reddish's point is public nuisance litigation historically was very much brought by sheriffs or attorney generals in a kind of quasi-public enforcement mode. Now public nuisance litigation under the doctrinal rules in most states can also be brought by private groups with sort of public standing if they can achieve that. So there's even fewer political controls. So that's just kind of by way of background of why this is such a hard topic in my view. What I wanted to talk about in terms of public nuisance and global warming was really three things. One, I'll just talk a little bit about the litigation that's happened so far, which, like most things environmental, has really focused on California, and why I think it's occurred. And my account there is very much like the account we just heard, which is the public nuisance litigation is kind of a Hail Mary pass for attention. I don't know if really you do a Hail Mary pass ever for attention, but you know what I mean. It's an effort to sort of open up the political floodgates by using the courts, really, because the litigation itself really isn't, in my view, designed to result in a judgment that would actually determine how to deal with global warming. So that's one thing. The second question is whether the historical precedents we just heard about and the kind of theory of public nuisance, to the extent there is one, really can support the courts getting involved in these cases. And my view is it doesn't. I think public nuisance has not historically been used and shouldn't historically be used for very complicated problems of commons management, where you have a commons resource like air, and you're trying to figure out how the rights to use air, the rights to use carbon should be allocated. I don't think public nuisance in the courts really is a very good fit with historical uses, even in terms of the expansive precedents. And that leads you to the final question, which was also brought up by the previous speaker, which is, given all that, what do we think about litigants nonetheless coming into court and bringing in these lawsuits because they say, look, the federal government isn't doing anything, the state governments may not be doing anything, or if they are doing things, what they're doing perhaps is preempted by federal law, even if that law isn't very active. Should there nonetheless be some room in the common law as a kind of last resort? And my tentative view is no. I don't think the courts, maybe they should be able to hear these cases, but my basic view is probably it's proper for them to dismiss them, even if the actual hearing and dismissing of the case serves some political function. The biggest public nuisance case about global warming so far, at least in terms of broad press, was the state of California's suit against the car makers. Maybe in a few days we'll have fewer car makers, but they basically sued all the car makers, both domestic and international, who sold cars, on the theory that the emissions from cars created a public nuisance in the form of global warming that had disparate or particular impacts on the state of California. For example, the loss of coastal land. And what they were suing was based not just on impacts within the state from cars, but really cars being used throughout the United States. And although they didn't include this in the lawsuit, logically it really should include emissions that happen all around the world, because we know global warming is an aggregate suit. That suit really followed on the frustrations of the state of California in dealing with global warming on its own and through resort to the federal government. California was one of the states that's petitioned EPA, both through litigation and otherwise, for waivers to sort of enact stricter standards for fuel economy. California has dealt with a very complicated set of preemption litigation with that. So in some ways, the public nuisance suit really was kind of California as a state's last push. It was kind of as a last resort. There's also been some interesting public nuisance litigation brought by private plaintiffs, but acting nominally on behalf of the public. The most interesting lawsuit right now involves an Inuit tribe, which is linked, its village is literally sinking, which is pretty much documented, and it sued Exxon and a variety of oil companies and a variety of other power generators on the theory that there's a nuisance to the broader public of Alaska and also to this particular tribe. And that lawsuit hasn't really gone anywhere. There have also been a variety of other ones. So far in this litigation, the litigation really hasn't proceeded, but the question is, should it? And even if it doesn't, is there some role for those kind of lawsuits? Historically, most public nuisance suits that involve pollution, which is kind of the closest analog to global warming, were largely binary. I mean, you had one city dumping sewage onto another city, or one state's power plant, or coal plants or smelters delivering pollution to another. And it involved the courts being asked to decide whether that exporting of pollution was a public nuisance. And that's a difficult question to resolve because in the absence of regulatory standards, how do you figure out how much pollution is too much? How do you weigh the economics versus the environmental aspects? But at least it's binary. You can get the parties that are relevant into court. The problem with the global warming litigation is almost by definition, the lawsuits are radically incomplete. California sues all the major car makers. Well, cars are a major source of greenhouse gas emissions, but so is electricity generation. So is private consumption. So are buildings. In theory, to have a lawsuit that actually dealt with global warming in a fair way that made an allocative decision, a judge would have to bring in pretty much everybody in the country, right? All sorts of, in what could not even be imagined as a manageable suit. So part of the problem with the public nuisance model for this litigation is, as a massive commons problem, it really goes beyond even the kind of expansive uses of public nuisance previously. One of the lawsuits that you just talked about was the Missouri versus Illinois lawsuit, which is a fun one to teach in Chicago, because Chicago, Illinois had this great idea of taking all its sewage and sending it down the Mississippi River, down to Louisiana, rather than having it come up to Chicago. You could see why that's beneficial to Chicago. And so they reversed the flow of the Chicago River in a kind of big feat. And you can kind of go look at the Chicago River. It's built into the kind of framework of Chicago. Well, not surprisingly, Missouri, which is downriver, got a little upset. In part because at that time sewage, it still is, but untreated sewage was associated, many people thought, with typhus outbreaks. So the state of Missouri sues Illinois, saying that Illinois had created, this is a long time ago, before the regulatory framework, Illinois had created a public nuisance by sending its waste downriver. And in some ways, that's an easier situation than figuring out what to do about global warming. You have a relatively small number of players, at least just the states on the Mississippi. You don't have all these varieties of inputs. You just have basically untreated sewage. But even there, the court essentially, although it used causation as the basis, said, we're not going to really decide this because we can't figure out who's causing the typhus, right? Typhus can be caused, or problems can be caused by all sorts of dumping along the river. And there's all these states, including Missouri itself, that's dumping on the river. All of you should have to clean up what you're doing. And I think that's an early indicator of the courts not wanting to get involved, there's the Supreme Court, in these very difficult commons allocation cases. Another example comes from water law. There's a long history of states suing each other over bordering waters, rivers or other tributaries that go into several states, about the appropriation of water. And there, the Supreme Court has exercised original jurisdiction over time, but increasingly tried to stay out of it because it's so hard to figure out how to allocate rights among different states over time. And if you think about the commons problem involved of allocation for global warming and greenhouse gas emissions, it really is just so massive compared to even the outward limits of what the courts have been willing to deal with. And I think that's proper because it's really clearly beyond their capacity. Well, if that's true, then what do you think about these kinds of lawsuits? One defense of the lawsuits, I think even some environmental groups have made, is we do this to get news, right? We get to get publicity. And from a judge's perspective, I guess from your perspective, that's not a very easy thing to deal with, right? Because someone's coming in and it's a case, you're supposed to decide it. And on the one hand, the court is there being used as a tool for a political purpose. Now, maybe that has some legitimacy. On the other hand, you might be concerned that if you have these kind of lawsuits, some of them really might go forward. And if they go forward, that could have negative consequences because it could interfere with the development of rational regulation. It could skewer the allocation of rights as they develop. So even if you think of it as largely a political exercise, and even if you think that's maybe constitutionally or otherwise legitimate, I think there's still a downside from the use of that model. And it's probably better for the states and other actors to try to use the state legislative and federal domain directly to deal with a problem that really is outside even the broad scope of something that we even think of as very broad, which is the law of public nuisance. So, thank you.